The police force structure. The police force in India is a huge body with multiple hierarchies. There is a separate police force in each state and union territory of the country. The Director General of Police, DGP, is the head of the police force in each state. The structure and working of the state police forces are governed by the Police Act of 1861. In some states, the state governments have slightly modified certain rules and regulations, and they are written down in the manuals of the police forces. States are divided into districts. The police force in each district is headed by a superintendent of police. A group of districts form a range, and each range is under the charge of a Deputy Inspector General of Police. In some states, 2 or more ranges form a zone, and each zone is under an Inspector General of Police. Each district is divided into subdivisions. An Assistant Superintendent of Police or a Deputy Superintendent of Police is in charge of police administration of each subdivision. Subdivisions sometimes are divided into police circles under an Inspector of Police. The basic unit of police administration is the police station. The number of police stations in each circle depends on its area and population. The Deputy Commissioner. At the district level, there is a system of a dual control of the police force. A Deputy Commissioner is in charge of administration in a district. He or she also acts as a district magistrate and a district collector. His or her functions include maintaining law and order, providing civic amenities to citizens and supervising development, collection of revenue, providing relief work during emergency situations, overseeing Panchayati Raj activities. The Police Act places the police force in a district under the charge of the district superintendent of police, but subject to the general control and direction of the district magistrate. Thus, the district magistrate has some important judicial functions and also oversees the functioning of the police force. The police station. The police station is the basic and the most important unit of police administration. We go to a police station when there is a disruption of law and order. The police is responsible for preventing criminal incidents and protection of life and property of the citizens. The police is also engaged in welfare activities such as providing help to the elderly, women, children, and the differently abled people. In cities, an inspector of police is generally in charge of a police station. In villages, a police station is under the charge of a station house officer. SHO. Other police officers in the police station are assistant inspectors, head constable, and constables. The area under a police station is divided into a number of beats, which are assigned to constables for patrolling and inspection. First information report. When a crime is committed, the aggrieved person should go to the police station of the area where the crime has taken place and lodge a written complaint. This is called the first information report or FIR. The police get to hear about a crime for the first time through an FIR, so it is called the first information report. The police can only initiate action after an FIR has been lodged. There are 2 kinds of offences: cognizable and non-cognizable. Cognizable offences are those where the police are authorized to begin investigations on their own after an FIR has been lodged and do not need a warrant, which is the court's written permission. Cognizable offences are mainly criminal cases such as theft, robbery, and murder. A non-cognizable offence is one in which the police cannot register an FIR, investigate or arrest without a warrant, that is, order from the court. Examples of non-cognizable offences are public nuisance, public mischief, and so on. They are comparatively less serious in nature. Procedure of filling an FIR. We have seen that the FIR is a very important document. Let us understand the correct procedure to file an FIR and how the police begin investigations after an FIR has been lodged. To report a crime, a person has to go to the nearest police station and meet the officer in charge to lodge an FIR. If the head of the police station is not available, the officer holding the highest rank should write down the written complaint. The complainant narrates the incident of the crime with every detail. He or she provides correct information about the location of the crime as well as about his or her own name and address. Lodging an incorrect FIR is a crime and a person can be prosecuted for it. Once the police officer writes down the FIR, he or she has to read it out to the complainant. Then the complainant has to sign it. The complainant has the right to ask for a copy of the FIR. If a person wants to file an FIR, it is the duty of the police to do so. Refusal to file an FIR is illegal, and a complainant can send a report in writing to the Superintendent of Police informing him about the refusal to file an FIR by a particular police station. Police investigations. Once an FIR has been registered, the police go to the scene of the crime and investigate the facts of the case. A police officer examines the scene of the crime, examines witnesses and suspects' records, statements, collects fingerprints and other technical evidences, seizes property and interrogates the accused. In case of cognizable offences, the police can arrest an accused on the basis of available evidence. However, in order to ensure that the police do not misuse their powers by arbitrarily arresting people, certain rules and regulations have to be followed while arresting a person. Some of these rights of the accused are guaranteed by the Constitution. The police has to inform the person the reason of his or her arrest. The police officer arresting an accused must be in his or her uniform with the name tag and designation properly displayed. The accused has the right to consult a lawyer of his or her own choice to defend himself or herself. The arrested person has to be presented before the court within 24 hours of his or her arrest. The police have to give him or her food and shelter after his or her arrest. The police has to prepare a memo of arrest containing the date and time of the arrest. After completion of the investigation, the officer in charge of the police station sends a report to the area magistrate. This report is called the charge sheet if there is sufficient evidence to prosecute the accused. If sufficient evidence is not available, such a report is called the final report. The police cannot punish an accused. They can arrest the accused, file a charge sheet against him or her, and produce him or her before the court. The police has to file a charge sheet within a given period of time, following which they have to free the accused from their custody. Trial. On receiving the charge sheet, the court initiates a trial. The accused should also have a copy of the charge sheet. He or she can deny the accusations against him or her and plead not guilty. He or she can employ a lawyer to defend himself or herself. If he or she is too poor to employ a lawyer, the court has the duty to provide him or her with a lawyer. A lawyer who defends the accused is called the defense lawyer. The lawyer who questions the accused on behalf of the government is called the public prosecutor. Before beginning the trial, the court makes inquiries to ensure that the police investigations are authentic. The accused is given the full opportunity to defend himself or herself. The trial can go on for a long period of time. In each hearing, the defense lawyer and the public prosecutor question the accused and the witnesses. After much debate and discussion, at the end of the trial, if an accused is found guilty, he or she is convicted and punished. Punishment may include fines, simple imprisonment, rigorous imprisonment, imprisonment for life, or even death sentence, depending on the gravity of the crime. Fair trial. The Constitution of India states that every citizen of the country is entitled to a fair trial. This is ensured in the following manner. It is the fundamental right of every citizen to be informed of the crime at the time of arrest. After arrest, he or she should be presented before a magistrate within 24 hours. A person cannot be ill-treated during his or her arrest and trial period. What an accused confesses in the police station cannot be used as evidence. The court should give a copy of the charge sheet and the statement of the witnesses to the accused. The trial has to be held when the accused is present and the accused can fight his or her case by presenting his or her witnesses. The judge should be unbiased and impartial. After the judgment, if any party is not satisfied, they can appeal to a higher, the public prosecutor. A public prosecutor acts on behalf of the state. The judicial system in India considers every crime a crime against the state. So the public prosecutor represents the case on behalf of the state against the person accused of a crime. He is appointed by the state. However, he is responsible for bringing about a fair trial and not seek the conviction of the accused only. In fact, the courts have interpreted the role of a prosecutor as a minister of justice who should place before the court all evidence in his possession, whether it is in favor of or against the accused. The aim of the public prosecutor is to assist the court in discovering the truth. Based on the evidence, the court will decide if an accused is guilty or not. Jails. Once convicted, the accused has to serve a jail sentence. The time he or she has to spend in the jail again depends on the nature of the crime. If a crime is proved, the accused can be sentenced to jail for a specific period of time. There are different kinds of jails for different kinds of crimes, such as central jails, district jails, and women's jails. Each jail is administered by some officials. The superintendent of jail looks after the working of each jail. The Inspector General of Prisons is in charge of all the jails in an area. Sometimes, after serving a jail sentence, when a person is freed, he does not get acceptance in the society. This might lead to frustration and he or she might indulge in criminal activities again. To prevent such situations, many jails provide the inmates with vocational training as well as meditation and other self-help programs to reform their criminal bent of mind. This way they are able to lead a dignified life once they come out of the jail.